Good morning, everyone. This is Alexandra, the Director of Education here at the American Apartment Owners Association. So excited to have you guys here. Couple of firsts. This is our first time having Brewer Offord and Pedersen LLP come and speak, and the first time that we're doing a statewide webinar topic. So this is going to be for California specifically. So all of you guys on the call do have rentals in California, and I'm sure you know that California is a pretty tenant-friendly state. So we thought this would be a great topic for California members to be able to have access to. So what I want to point out is a couple things before starting. The first one is we do have an outline of the presentation that I've included for you on the side panel. If you can't download it for whatever reason, don't worry. I can always send it to you tomorrow. However, if you can download it, you can download it right now and print it to follow along and take notes. However, tomorrow I'm going to be sending you guys a recording of the entire presentation. So if you miss anything, don't worry. You can always go back and look at it tomorrow. And also, too, we are going to have a 45-minute webinar, more or less, with a 15-minute Q&A afterward. So be sure to start jotting down some questions. We will address them all at the end. I'll be reading them off, and Ashlee and Adam will be answering them. If we don't get to all of the questions, we will be answering them via email. So still put them into the question box, even if it's towards the end of the webinar. And we will also have a few poll questions, so stay on the line and listen out for those. We'd love to hear your feedback and understand where you guys are at in terms of your eviction experience in California. And I would like to next introduce our speakers. So starting with Adam L. Pedersen. He's a senior partner and real estate attorney at Brewer Offord Pedersen LLP. He has 8 years of experience as a relentless advocate for real estate brokers, landlords, property managers, and agents. He's a licensed California real estate broker, fluent in written and spoken Spanish, impressive, and he focuses his practice on issues relating to real estate transactions, including non-disclosure disputes, agent responsibilities, close of escrow issues, title disputes, and he has over 5 years of litigation experience, having represented brokerage and insurance companies in a range of issues. And he went to law school at Santa Clara University, graduated 10% of his class, and received the Best Oral Advocate Award for his participation in the Jessup International Moot Court competition. And he's currently the 2018 co-chair of the real estate section of the Palo Alto Area Bar Association. And he's frequently sought out to speak to groups of real estate agents, brokers, title representatives, escrow agents, property managers like you guys on the call today. So we're very looking forward to hearing some of Adam's experience. Ashlee Gonzales is a junior partner and real estate attorney at Brewer Offord Pedersen LLP. It's a boutique real estate law firm located in Silicon Valley, and she helps real estate investors, homeowners, landlords, agents, and brokers with issues relating to partition actions, unlawful detainers, duty of care disclosures, and other real estate legal issues. Most recently, Ashlee was second chair in a broker defense trial where she secured a unanimous verdict on every single count, protecting her client from claims of fraud and negligence. She's the 2018 co-chair of the Palo Alto Area Bar Association real estate section, and she frequently speaks to real estate groups such as the Santa Clara County, Silicon Valley, and San Mateo County Association of Realtors. So that being said, I'm very thrilled to have both of you guys here today. I really appreciate you carving out some time of your busy schedules to present such a great topic for our AAOA members and other guests on the line. So I'll hand it over to you guys, and feel free to get started whenever you're able to.
All right, thank you and good morning. This is Adam speaking. First of all, I'd like to thank you for the very kind introduction, and I'd like to thank the association for letting us do this today. I think Ashlee will agree with me that one of the most exciting things that we get to do in our career is work with folks like yourself and providing what we hope to be an educational experience to get them a better idea of the laws that affect the way that they do business, and hopefully develop better policies and practices to help keep them out of trouble in the first place. It's one of the most enjoyable aspects of what I do day to day. And so again, thank you for the opportunity to be here, and look forward to walking through this material with everybody and answering any questions that you all may have upon conclusion. So first things first, we are attorneys, so of course we have to have a disclaimer for everything. And this one, is, you can see, is a very long one, very wordy. I will let all those online read it to themselves. Suffice it to say, we are providing this service for informational purposes only, and hope that you get something out of it. And that if you do need an actual attorney at some point, you consider reaching out to either ourselves or someone you trust to get advice on your specific situation. Because one of the things that actually we'll be talking about today is, very much of what happens in the law and the eviction process and otherwise is very case specific. And so if you've got an ongoing situation, critical that you get personalized and customized advice. First things first, we have some poll questions that we are asking that you all answer. I will have Ashlee walk through those and introduce herself. And in that way we can kind of guide our talk with some information about what you guys are seeing on the ground.
Hi everyone, Ashlee speaking, and piggybacking off of Adam, thank you for attending today, and I'm hoping that we can provide you with some information. We always have clients tell us, oh, I wish I would have talked to you before I did this or before I did that, and this should help you prevent any headaches or frustration. So for poll question number 1, how many units do you manage? That can range from 4 to 100, 200. We're really looking to help all types of property managers and owners alike. And so we just want to know how many units you manage. Second poll question coming up.
I asked Alexandra to show the results.
And Alexandra, can you show the results of that once they answer the question?
Yes, we have about 77% of people voting. So I'll just give like a few more seconds to maybe hopefully get closer to 100. I think I still have a few more coming in. Okay, yeah, that's good. I'm going to go ahead and show that and share. So I'm not sure if you all can see it, but we have 69% in the 1 to 49 unit range. 50 to 99 units is 15% of the callers. 9% of the callers are at 100 to 149, with 4% at 150 to 199 and 4% at 200 plus.
Sounds great. Okay, next poll question. On average, how many tenants do you have to evict in a year? Hopefully 0, but it happens, and we want to know how many, 5 or fewer, 5 to 10, 11 or more, or I've never evicted a tenant. So we'll give you a minute to answer that. Okay, Alexandra, how are the results looking?
Looking like we're at 80% here, so I'll go ahead and close it out and show you guys the results. Interesting. A lot of people haven't evicted a tenant. That's good.
That's a great thing. That means that your vetting processes are really sharp, but it looks like there are some that have had 5 or fewer. So either way, if it's coming down the pipeline or you're currently involved in one, this webinar should help.
And to dovetail into that, that's not inconsistent with what we see here in practice. A lot of landlords only may go through, especially smaller landlords, or smaller property managers may only go through a couple of evictions in the span of 5 years. And so that's one of the important reasons to be prepared for those issues when they come up, because if it's not something that you're doing regularly, which is great, the converse or the negative aspect of that is that you probably don't have a lot of experience in it. And so hopefully we can red flag some things for you guys today that will help you not run afoul of the law, because so much of what eviction about is very specific processes that need to be followed. So Ashlee, the next one.
What is the most common reason you need to evict a tenant? So those include non-payment of rent, damages to the property, other lease violations, or illegal/drug-related activity. So go ahead and answer that. We'll give you a few seconds.
And while you're answering that, I'm interested to see the results in this question. And I know the fourth answer on the list is probably going to be the least common, or at least that's my guess based on practice. But we are seeing a surge in questions surrounding that one specifically here in California with the advent of legal cannabis and its relationship to the rental process and by extension the eviction process. So although it says illegal or drug-related activity, I would include in there for purposes of the poll today if you've had issues with regarding an eviction or potential eviction due to legal cannabis usage as well, or medical cannabis usage. That would be interesting to discuss.
Yeah, interesting point. It looks like most people have voted in. Here are the results. 87% non-payment of rent, no surprise there, but 0 on damages. 9% other lease violation, and 4% illegal drug-related activity. So
interesting. Yeah, I'm not
expected.
surprised by the majority just due to the rent prices in the area. That's typical and tends to be the most common reason.
All right, so we're going to start by just talking about the eviction process in general and walk through that. Now, eviction, often called unlawful detainer. If you visit an attorney about an eviction, that's probably how they'll refer to it. That's the nomenclature we use in the industry, although eviction might be more common in regular usage. Unlawful detainer is sort of a special animal under the law. It's an expedited court procedure. Although I'm sure most landlords feel it's probably not expedited enough, it is certainly much faster than your typical court process. The typical case can endure 2 years or more in the court, whereas an unlawful detainer case and its special procedures can be completed within a much, much shorter time period. In fact, the idea is that most unlawful detainer cases should go to trial within about 20 days from the filing of the answer by the tenant. So it's greatly expedited, and for that reason, it's only available in certain circumstances, and it's only can be conducted following very strict procedures. So starting then with the reasons you can evict, that kind of goes back to the poll question we just asked, but we've highlighted some of the major ones here. Obviously, failure to pay rent is a very clear instance in which one can start an eviction. Breach of contract, so that goes more toward the usage of the property. You'll see there in the illegal use of the property, we've highlighted Airbnb and drug use. Those tend to be the more common illegal uses, and frankly, the Airbnb issue is one that's becoming more prevalent. For example, here in Palo Alto, in most residential districts, it is prohibited to use properties for Airbnb type services. However, the issue has been brought before the city council, and the city council has essentially deferred any action on it. So while it's illegal in a strict sense, it's practically speaking, not an issue that the city's going after. That said, as a landlord, that ambiguity doesn't play in your favor, and nobody wants to be caught flat-footed if the city or the county or whomever does decide to enforce those regulations. So that is another instance where you may want to remove a tenant. And then finally, the other probably most common alongside of failure to pay rent is simply the expiration of a fixed term lease. Most landlords, or many landlords, prefer to do a year lease or a 2-year lease, and the expiry of that lease is certainly grounds to remove the tenant if the lease is not renewed.
Great. So next slide. One of the biggest issues that we hear from our clients is they don't know that there's an issue. And so we want to just go over how you can find out and ways that we've advised our clients to discover the problem if there is one. First, you must be mindful of Civil Code Section 1954. I highly suggest you write that one down and look it up. 1954 provides for exact instances when you can enter the property and what you need to do In order to enter as a landlord or a property manager, typically it's 24 hours notice, but that can vary. Some reasons could include emergency, showing the property, amongst other things. So that's one way that you can find out something's going on, is if one of your reasons to enter is under the code section. Other unorthodox ways would include talking to the neighbors. Get to know where your property is at, get to know the neighbors, talk to them, figure out, who's going in, who's going out. It can seem a little intrusive, but if it's your property or if you're representing the owner, it is important. Also, take a trip down to the city or county and see if the property's been cited for any noise violations or any use violations, if the tenant has tried to make improvements, obtaining permits, that type of thing. Usually it's illegal to modify a unit without the landlord's consent in writing. So that's one violation. And then also police reports, get to know your local department and figure out if they've gone to the property and why, and figure out if it's a violation of the lease.
All right, and just a brief note, since we're at the sort of outset of this eviction process, a critical issue identified on this slide here. You can tell it's critical because we've used red letters and some orange tiger stripes highlighting its legal importance. I cannot understate the importance of this piece of advice. This is one of the ways in which most landlords find themselves in hot water. It's simply unacceptable to engage in what we call self-help. So that is taking action outside of the unlawful detainer process, outside of the court process, without, of course, the consent of the tenant, to either change the locks or turn off utilities, or even simply, being at the property every day, or otherwise engaging in behavior that might be construed as harassing to the tenant and interfering with the tenant's use and enjoyment of the property. And I know that this can be absolutely frustrating for landlords, especially if you've got a tenant who's damaged or is damaging the property, or you've got a tenant who's damaging the property and not paying you rent. It's very frustrating to have to sort of sit on your hands and allow the court process to play out. But trust me, even if the tenant is in the wrong in the underlying lawsuit, that will not be a defense for your self-help. You will end up liable, and you'll end up snatching defeat from the jaws of victory if you choose to engage in self-help. There's very little defense to any of these measures. So just want to put that out there for everybody. If you have questions about what self-help may or may not be, that's a great question for the end of the session. I'd certainly love to address that with people.
Okay, next, before you can evict a tenant, the very first thing you must do is give notice. And I've listed the different types of notice. Those include 3-day notice to perform or quit, 3-day notice to quit, and a 30 and 60-day notice of termination. Depending on the violation or the reason why you are being forced to evict the tenant, the notice will vary. And I would focus more right now on 30 and 60-day notices. This is where I see the most problems with our property managers and landlords. Typically, a tenant in this area, especially if there's rent control or if they've been there a long time, 60-day notice is required. 60-day notice is required for any residency in the unit for more than 1 year. And that's very important, because if you go and serve them with 30 days and you file the lawsuit, it's a complete defense if you serve the incorrect notice. Also, please write down this code section as well. I'm really big on code sections. Adam will agree. They control the whole eviction process. 1946.1. And I've actually encountered this in a lawsuit, and it didn't bite us. It was a new law, and we hadn't changed our forms yet. It was literally a day or two old. And for 30-day and 60-day notices, you have to include language about abandoned property, and not including this results in a faulty notice, and you would have to start the eviction process all over again. So really be mindful of that. Check that code section out, and they even provide a blurb that you can include on your notice.
Yeah, and very important to go back to Ashlee's note about code sections. That goes back to what I was talking about in the beginning, which is unlawful detainer being a very specific process, and it's very unforgiving. And, literally cutting and pasting the language from this code section into your notice is what the law requires. And anything short of that doesn't work. With respect to notices, a lot of landlords use their own forms or draft their own after research on the internet. I'm not saying that can't be competently done, but I am saying it's not worth it given the consequence of, if it's done incorrectly, of having to start the unlawful detainer from square one. And by square one, I mean serving the notice all over again. So you really have to be careful in these notices. For example, those of you that are realtors, member of the California Association of Realtors, they've got great forms for this purpose. No need to reinvent the wheel. Find a trusted form that you like, that you have access to, and then stick with that. There's no room for creativity here in drafting of the notice. Woo. And for those of you that saw that, that's the rest of the presentation. I hope you enjoyed it. So the next part of the process after the preparation of the notice is you got to serve it on the tenant. And the way that's done, again, is unsurprisingly provided for by statute, and it's got to be done in several different ways. I think for practical purposes, if you're a landlord, either a novice landlord or a small landlord or a large landlord, I would just always refer you to the fourth item on this list, which is hire a process server, or make sure that your attorney hires a process server. This is an area where I see landlords continually trying to save money because it can be, around $75 to have the service done by a process server, but it's really not an effective cost-saving mechanism because, again, like the notice itself, if it's not served correctly, you are back at square one. You're starting the process all over again. The court filing fee is approximately $500 for an unlawful detainer. So you can do the math. You lose that filing fee if you've got to start over again. You're going to have to pay another $500 to restart the unlawful detainer, all for want of a small fee to the process server. Here's why it's good when the process server does it. Number one, they know how to do it. It's what they do for a living. And number two, there is a legal presumption that if a process server completes the serve and signs what we call a proof of service under oath, that service was done correctly. And the burden shifts then to the tenant to prove that service was not correctly done. So for your fee to the process server, you erect a legal presumption that you've done it correctly and shift the burden to the other side. So not only is it practically a good idea, but it's also a legal advantage as well. No, I'm not a process server. I've got no skin in this game, but it's just worthwhile. That said, there's a few ways you can serve. You can serve personally by, as it sounds, delivering the notice directly to the tenant. You can do what they call a substitute service or post and mail service. That's where you go to the property, you post it prominently at the entrance to the property, and then you mail a copy to the tenant at the tenant's address, at the address of the subject property where you're going to conduct the eviction. So you've got to give notice to all tenants and residents, and that includes people who may not be named on your lease. So everyone needs to get notice, and even those who are not on the lease actually have a legal right to that notice and potentially the ability to participate in the unlawful detainer. It's less common, but it can happen. So the net I'd say is, find a process server you trust, work with them. It's going to save you time and money in the long run. And then if you wanted to go it on your own, there are certainly some good guides out there, but this is one of those technical areas where people slip up, and it is one of the first things that the tenant's attorney is going to look at when the unlawful detainer starts off.
So next slide. Once you've drafted your notice and you've served it on the tenants or tenant, you need to file a lawsuit. And this can only occur after the time to cure has expired in the notice. So if it's 30 or 60 days, make sure the notice period completes, and that counts from the day after service, and then you can file the day after the expiration. A lot of people get antsy and they want to file quickly, and again, this could result in you starting from square one if you violate the notice period. So make sure you wait for the complete amount of days to elapse. When you file the lawsuit, there's several forms, but the primary ones you need are the summons, complaint, and civil case cover sheet. The prejudgment claim to right of possession is a little more complex, and we'll get into that in other webinars. But we can provide you some input on when and when not to include that. So once you draft those, you need to file it, and then you need to serve it. And depending on how you serve it, either by personal or substitute service, that varies the amount of days the defendant has to respond. It could be either 5 for personal or 15 for substitute. So just be mindful of those criteria and make sure you file all the necessary forms in your instance.
All right, once the lawsuit's been filed, then you're what we would call the process of active litigation, or just simply litigation. Litigation just refers to the court process that occurs once a lawsuit is filed, from the time of the filing of the lawsuit up through the time of trial, and ultimately a judgment, which is, the judge or the jury's decision with regard to the outcome of that trial. So that's a very broad overview of the litigation process set out before you on this slide. But I think relevant for the eviction process, suffice to say, it follows a very similar process as a traditional court case. There can be discovery, which is the gathering of evidence by both sides. There can be motions, which is a request to the court for specific relief during the litigation process before trial. And I think most important and most common for what we see out there are the top two items: and default judgments and settlement conferences. So let's start with default judgments. It's not uncommon that the tenant, especially in a non-payment of rent situation, knows and understands that they're on the losing end of this unlawful detainer, and really all they're doing is buying time while they're trying to find another place to go. So quite often what happens is you file your lawsuit, and the time for the tenant to respond goes by, and no response is filed. At that point, the tenant's in what they call default. You want to be wary of that because you want to jump on it. You don't want to give the tenant an opportunity to file a late response, because the court will accept it. The court will not reject a late response if you've not sought default. So you want to watch that time period for response and then jump on it, because once default is entered, the tenant's going to need to get a court order to set that aside, and that puts you, from a negotiation standpoint, in the driver's seat in order to press the tenant to leave the premises short of completing your unlawful detainer in the form of a trial. And so that suggests what we have here in the second item, which is a settlement conference. By and large, most cases of all kinds in the state of California get settled or otherwise resolved short of trial. The last statistic I heard was it was about 98% of cases do not go to trial. So it's certainly the exception. I think eviction actions probably have a higher percentage that go to trial, simply because they're shorter term and quite often more hotly contested. But that being the case, most still settle. As a practical matter, from the landlord's perspective, you've got two things going on. One is emotional, one is a business issue. I encourage landlords constantly to try to set the emotional issue aside, but being a landlord myself, I certainly understand it. And that's, you've worked hard to secure this property for the tenant, keep it up for the tenant, and then the tenant doesn't pay you for it, and it feels like you're getting burned, and you are. But the bottom line is, the name of the game is getting the property empty and getting it rented back out to somebody so that it's profitable. You can't let the emotion of the issue drive your business decision about how to get that property reoccupied. So two things generally are at issue at a settlement conference: time and money. Money being the amount of rent unpaid or due, and time being how long to get the tenant out. And so those are the typical variables we see negotiated in an unlawful detainer. But most counties have a special hearing called a settlement conference that occurs shortly before trial. And it can be quite often as informal as the judge pulling everybody in prior to setting the trial courtrooms and saying, okay, everybody go out in the hallway and see what you can do to work things out. And you'll have, several groups of different cases out in the hallway, literally in front of the courtroom, trying to negotiate a settlement. But what we're really talking about is time and money. And usually it's possible for us to come to some sort of resolution that's amicable between the two. And that results in not only, something, a predictable outcome, but also a court enforceable outcome. Because we're in litigation, because we're in this context, we can actually secure a judgment for the landlord that simply sort of waits in the wings or is held in abeyance if and until the tenant does not comply with either the time or money components of that stipulation. So if the tenant agrees to pay, $1,000 in rent and be out in 30 days, they've got to do that. Otherwise, it's enforceable. So that's the way most of these things wind down. So the litigation process either finds itself solved by that type of stipulation or by a trial.
So next, we're going to get to the crux of why you're here, avoiding legal pitfalls in California eviction. So I'll go over briefly the different types of pitfalls that we see landlords and property managers encounter. Those include improper notice, like we discussed prior, filing suit too early, wherein you file a lawsuit before the notice period expires, accepting rent from the tenant. This can be tempting to do, and it can basically disrupt your whole eviction action. So we have to really be careful with that. And also service issues regarding the unlawful detainer complaint and the notice. They both can result in a total pitfall for your eviction.
So we've spent some time on this earlier, so I won't spend too much more time on it here before. I would say to those listening, treat this section of the presentation as sort of your red flag list. These are the areas where, when you're involved in an eviction, your radar should be on, and you should be looking out for issues that may affect the eviction process. And if you're working with legal counsel, these are certainly topics you want to be discussing with them. So improper notice is always a big one. You want to make sure that notice, again, is done correctly, using the format that's appropriate for the type of eviction that you're doing. You're waiting till the end of that notice is over, and you're doing all that because an invalid notice is a complete defense, right? So that's why this is such a big pitfall. It's binary. It's either is or it's not. So definitely an area where you want to be very cautious.
Next, filing suit too early. Again, this occurs when the landlord is so anxious to get the tenant out and they file the unlawful detainer before the notice period expires. One big thing that I have to be cognizant of, and even more so if you don't practice law on a daily basis, is be mindful of holidays and weekends and know what those days do. So for notices and for your service of a complaint, it extends the amount of time the tenant has to do whatever they need to do, an additional day or days until the next available court day. And so if the tenant's answer is due or they need to pay rent, on a Sunday, arguably they get until the next court day to do so. If the court day on that Monday is a holiday as well, they get until Tuesday. So just be mindful that, a lot of people try and go and get a default because a tenant hasn't answered a complaint or file a lawsuit because they haven't cured the notice, and a weekend or a holiday, prevents that from happening and actually extends the period an extra day or even 2 to 3 days.
So accepting rent, this one is tricky, and so from the outset, I think the best advice is that if you've commenced an eviction and the tenant offers up rent, you're going to want to do an evaluation of the legal impact of that before accepting the rent, because as it says here, in most circumstances, acceptance of rent can basically waive the landlord's right to continue with the eviction. So be very careful in doing that, especially in non-payment of rent cases where it's a 3-day notice to evict, and you accept rent after that 3-day notice. We have won lawsuits on behalf of tenants. Don't kill us. We sometimes represent tenants as well as landlords because that this was not adhered to. So it's very tempting because, again, you may be out money. And it's nice to get an offset to your losses, but it's not worth it. Again, the name of the game is getting the tenant out and getting the property reoccupied by a good, stable rent-paying tenant. One thing that comes up a lot in practice is a lot of landlords these days are accepting electronic rent payments, and this almost always comes up as a fear landlords have when they go to evict for non-payment of rent, and they say, well, what if my tenant, deposits my rent into the bank account or sends it to me via Venmo or PayPal or whatever service you may be using. The good news is that the courts have weighed in on this, and the tenant's simple delivery of rent electronically is not considered acceptance of that rent by the landlord. So you don't need to be afraid. If you prefer taking rent electronically, you can continue to do so. It's not going to cost you your eviction. But you do want to be cognizant, because in the cases that have gone up before the court, what happens is the landlord, notices within a reasonable time period that the rent's been paid that way, and then refunds it to the tenant. So you do have to refund it. You do have to watch for it. But the tenant's unilateral act of just depositing it is not going to be considered acceptance of rent.
Next, service issues. Again, make sure you serve all tenants, and this doesn't necessarily happen by your process server going to each person in the property and handing them a notice. It happens in the drafting of the notice. So you want to make sure you have language in there that says to all tenants in possession or to all tenants in the property. Don't just mention the tenant on the lease. Make sure you include anyone and everyone that could be in there that have tenant rights. Also, as we discussed, personal, substitute, and posting and mailing are common methods for service and notices. And there's one hiccup that we encounter a lot with posting and mailing, and you really need to know that service is not effectuated until the notice is mailed. Sometimes we have process servers that might not necessarily know the rules. They post the notice and then they wait a week to mail it. Well, service doesn't count until it's mailed. So make sure you stay on top of them, or you have your lawyer stay on top of them, and really make sure that it's mailed, and then start counting from that date. And again, I've seen judgments set aside. Again, Adam mentioned we defend tenants as well. We've been able to set aside judgments because of service issues. So it's really substantial.
All right, so now we're going to go over some common tenant defenses to the eviction process. I'm just going to trot quickly through the outline here of the 4 that we'll cover. So common issues that we see, and these are all, by the way, issues that we're actively dealing with on behalf of landlords right now. I mean, I'm looking through this list of 4, and I can probably name cases that I'm currently representing property owners or managers, and they're all facing these very common defenses. This is where the sort of tenant-friendly laws in California come into play strong, what we call the tenants' rights statutes. So the law with respect to these defenses is very tenant-friendly, which is why these defenses are so common. And this is just a feature of California law. It's a product of politics. But let's trot through some of these and give you some ideas of how to confront them if they come up.
First, an illegal unit. This is when the unit's not permitted. The tenant has the same rights as a tenant in a legal unit, so you really need to be mindful of that. A lot of rent control statutes specifically say that they are protected under the statute if the unit is not permitted, and this could be if it's a single family home. Rent control usually only applies to multifamily properties, but when the unit is not permitted, they fall under the statute in some cities and counties, so you really have to be mindful of that. In some areas, even you can recover all rent paid in an illegal unit, but the court is usually more practical than that. There's a LA County court case, an appellate case, that the tenant was not responsible for rent increases in an illegal unit, so the court cut the landlord a break. But in some cases, you can have to pay back all the rent. But just be mindful of that, and the tenant will bring that up, and they usually go to the county, they go to the city, and they figure out if you do have permits for that unit, if they suspect any foul play.
Yeah, and to address that issue as well briefly, the illegal unit issue is coming up more and more nowadays with the tight rental market that we have. People are putting into service converted parts of existing structures and so on and so forth. And while it's a bit outside the scope of this presentation, I want to put everybody on notice that California as a whole, and some local jurisdictions, like, for example, I'm thinking of San Francisco specifically, have enacted a lot of new laws very recently that affect what we call accessory dwelling units. And that can be a unit that is separate from a pre-existing residential structure, or it can be a converted portion of a home. So you can wall off half your house, and that can also be considered an accessory dwelling unit, or ADU, under current California law. California law has greatly streamlined the process of normalizing or legalizing, for lack of a better word, these units. So if you do have a conversion unit or a unit in your backyard that you'd like to rent out or are renting out, the process nowadays to bring that up to speed legally and get it permitted as a residential unit is much easier than it was a few years ago. So there's really no reason to address it, because there's no need to expose yourself to that liability when California law really has given you some options now. So that can be a lecture in and of itself. So we'll move on from that. But if you guys have questions, by all means, bring them up. So one of the major areas that we see raised is discrimination. So discrimination generally has to do with, the landlord cannot discriminate based on family size, race, gender, etc. I think most landlords understand that, and I don't think most landlords are intentionally discriminatory. I mean, I've seen it. I've seen landlords that possibly were making decisions based on race or gender, but it's certainly uncommon. I think what is more common is that people misunderstand the protections that extend to things such as family size or status is a common one, and also discrimination with respect to disability and things related to disabilities. I'll give you some examples that I've seen in practice that I think highlight the problem. I have defended once a owner / manager of a, I think it was a 10 to 15 unit complex, and they had posted signs that there was no ball playing to be allowed in the common areas of the apartment complex. Very logical, I think, limitation in the landlord's mind. And it was basically because there had been incidents of balls, damaging the property or breaking windows, and even other tenants complaining of, people playing ball in the common areas and feeling like that was presented a risk to their safety. So what seemed to be a reasonable limitation on property use ended up being the basis for the federal government to bring a claim against that complex for familial discrimination, because it targeted families with children. And arguments aside about whether or not that would have held up in court, it was brought before the federal fair housing authorities, and they brought a claim, and we ended up having to defend that claim. And it was the position of the federal government that it ran afoul of the law. So you got to be careful with things like that. Something that seems innocuous may not be. Disability, most common issue I see people running into is service animals, right? And I can go into some detail if you guys have questions, but there are organizations that set this up and basically kind of poach landlords by sending communications saying, hey, I have a dog that helps me with my depression. Can I bring that animal on board? And the landlord reacts in one of two ways. One, saying, no, we have a no pets policy. Or two, saying, yeah, but I'm going to have to charge you a pet deposit. Under both circumstances, you have run afoul of the law. Emotional support animals are treated equally as a seeing eye dog under the law. And while it was phrased kind of, in my opinion, in an underhanded manner to set up the landlord, from the law standpoint, that's a violation of the anti-discrimination statutes. So with respect to service animals, be very careful. I can give you some specific tips as to how to avoid that setup if you have questions about that at the end of the presentation.
Next, one of the biggest issues I work on both sides, but just focusing on the tenant defenses, is retaliatory eviction in respect to habitability. And so there's an issue in the property and the tenant comes to you and complains, or they complain to the county, or they just have a general legal right that they use. One of those is repair and deduct. And I have articles on that. You can email me, ask me questions about that. I can go into more detail. But if the tenant uses any of their legal rights in respect to habitability, arguably you can't evict them for 6 months. I've run into problems with clients thinking that, it's not fair or this is crazy, but the law is pretty blatant on this and the courts are very strict about it. And what happens is the burden is on the landlord to prove that they're evicting the tenant for a reason outside of the complaint. if they have paid their rent, they're not doing anything else illegal, and you just don't want a tenant in there that complains every other week about a leaky roof or the HVAC not working properly, and so you want to get them out of there. That's going to be a complete defense for the tenant, and you will have to prove otherwise. And so I think that's a pretty significant defense.
And the last one isn't so much of a defense as it is a reality. The tenant's objective in any eviction process is to delay it as long as possible because they've got the advantage of possession. You can't, as we talked about before, use self-help. So they've got the property tied up and potentially rent-free for a certain period of time while the eviction process is ongoing. Bankruptcy filing can stay all of that, so it can basically put a freeze on the unlawful detainer pending the resolution of that bankruptcy. Definitely seen this happen before. If this happens, this is absolutely, you're going to want to make sure that you've got a good lawyer who knows at least something about the bankruptcy court, because you can go into the bankruptcy court and get relief, but you need to do it quickly because that process is itself not, something that happens overnight. So just know that it's not a death knell to your unlawful detainer. It can be dealt with in the bankruptcy court, but you've got to move quickly if this is the delay tactic that they've used.
So one more slide, I'm going to talk about hostile tenants. And I know there's other slides in your handout, but I want to make sure I save time for questions. And we pretty much covered everything already that's in the remaining slides, but feel free to ask us and email us. I just want to make sure that you have a chance to ask us questions. So for hostile tenants, and if you're going to evict them 9 times out of 10, you're going to encounter this. And there's some tips that I provided to try and help that. One, hire a property manager to work as an intermediary. Usually it's a middleman. They can kind of play both sides. They could play good cop. You could be bad cop, just for example. I've really found that works great, and it keeps the relationship at arm's length. Second, tread lightly. The courts are very tenant friendly, as you've heard us say. Just make sure to not be super aggressive and limit your contact with them as much as possible. You really want to keep it professional. Don't text them all the time. Call them, because you're just building a case against yourself. Again, only contact them when necessary. Make sure you perform eviction by the book. Don't try to be creative. Don't do self-help. Just keep it to a minimum, because anything you put in writing, anything you put in email, I guarantee the defense attorney is going to use it against you. You're going to see it in court, or you're going to see it during settlement negotiations, and it's going to hurt your case. Also, consider a buyout to provide incentive to the tenant. However, be mindful of the city and county requirements. Sometimes a landlord thinks that they're being generous to the tenants, and the tenants will be excited. They're getting a $5,000 payout, but that county might require $8,000. And so you could be offering a favor to the tenant in order to maintain the relationship, but you could be violating a county ordinance. So if you're gonna go this route, make sure you research the ordinances and make sure you're not violating those, because then that's a whole other slew of problems. So Alexandra, we've concluded our presentation, and we want to head to the question portion, if that's okay.
Yeah, fantastic. Thank you guys. That was super informative. I do see a few have come in. For those of you who haven't put in questions yet, definitely start typing in there. I'll start with the first one. I have one question from David. He's saying, I have a troublemaker tenant, and he is accusing me of racial discrimination because of a rent increase that I gave. What do I do in this case?
So my prior slide, I think, hits on this exactly, and it's keep contact to a minimum. And in this instance, I would put everything in writing. Don't do any phone calls. I would just imagine yourself having to go to court. God forbid you have to, but put everything in writing and write it in the way that you know a judge is going to be looking at it, and really support everything you do. And then also, I would review your lease and also the county and local ordinances to make sure that you're not raising the rent in violation of those. Sometimes there's restrictions depending on what city or county you're in. But really, I would just maintain contact to a minimum and put everything in writing, and just be confident that you've conducted yourself in a proper manner. And whatever they're saying, whatever they're doing, it's just, they're pounding their chest trying to scare you. But if you do everything in writing, you can be confident that you're going to be able to defend yourself more than likely.
All right, and the
Yeah,
next question. Oh, go ahead, Adam.
Oh, sorry. Yeah, I would just say document. I mean, email is a great tool. Make sure that everything is in writing. And unfortunately, once that issue has been raised, it can be tricky. And I would say what David should probably do is document everything and sit down with an attorney, if only for an hour or two, to map out a strategy with respect to that tenant's ongoing occupancy of the property before making any decisions about eviction.
Okay. And from Vipul, what if we find out that the property has been abandoned and the tenant has not paid rent? What's the next step?
So there's a specific code section that regulates abandonment, and I know it seems obvious. We all know what abandoned means, but this slide in particular talks about the property, but there's also statutes on when a person has abandoned a property, and there's certain things that they have to do in order to actually legally abandon. They have to hand over their keys. In a lot of cases, they have to make some affirmative action to conclude their residency in the unit. And if you're not sure if what they've done amounts to an abandonment, I highly suggest you seek legal help, because if you go into the property, you relet it, who knows who you're dealing with. They're going to come back and say, hey, I still live here. I was just on vacation in Europe for 3 months. You never really know. And so you want to try to do everything you can to make sure that lease is terminated before you relet the property.
Yeah, just a little war story based on that same scenario. I once defended a property manager, a real estate agent involved with a rental. Well, it wasn't a rental. It was actually a tenant who was occupying a property after a foreclosure had occurred. And, again, no self-help. Just because the foreclosure happened doesn't mean that the tenant's rights are terminated. So the tenant had actually left the property. And so the real estate agent managing the property went there, did an occupancy check, saw that the tenant had left. There were still some belongings in the premises, and the locks were changed, and the property was turned over to the lender, the foreclosing lender. But that lock change was arguably self-help eviction, because no court process had removed the tenant and there had been no formal abandonment. And so a lawsuit was generated. Fortunately, I should say, we were able to do some digging and find out the tenant had in fact taken up residence already in another apartment several counties away, and had done so, even prior to the foreclosure being completed. And so we were able to defense that case. But on its face, it did present a problem, because they did not adhere, again, to the statutes regarding abandonment.
Okay, the next question from Cora. What's a buyout?
So a buyout, I have about 3 or 4 of these going on right now, is when either the tenant needs to break the lease early or the landlord wants to break it early, and they buy out the remainder of the lease, essentially. There doesn't have to be a set dollar amount unless the county or city provides for that. I believe San Francisco has an extremely high dollar amount. It's around $8,500 per tenant for just certain units. It depends on the size. It's pretty crazy, but a buyout is essentially you're making a new contract. You're saying, okay, if you leave early so I can sell the property or I can move back in, I'm going to provide you with a certain sum of money. So you're buying their rights in the lease.
The next question from Felicia. Can we serve a notice via email?
The simple answer to the question is no. No, you cannot serve a notice by email. The code provides for certain methods of serving notice, and so that's what you've got to adhere to. As with all things in the law, it's not 100% there may be some ways to address that issue, but by and large, you're going to want to stick to the traditional methods of service that are provided for by code.
There's some exceptions to that. 1954, the code section, if you want to serve notice to enter the property, email notice is proper, but that's one of the few instances where you can do it via email. I just want to put that out there.
Okay, and from Magid, does the eviction process change if I'm renting out a room in my house?
I think that I'll give everybody the lawyer answer. It depends, but that's not valuable for anybody. So the answer is generally speaking, no, it doesn't. It's the same process. It does have an effect, and it can have an effect in certain jurisdictions. For example, with rent control, the fact that you live in the property with the tenants may change the acceptable bases for you to conduct an eviction, as most rent control statutes have exemptions for property that is shared between the owner and the tenant. No, but generally speaking, if you rent out room by room, for example, each room rented is going to be treated at its own individual tenancy, and you're by and large going to follow standard eviction procedures.
Okay. Following that same train of thought, there's a similar question from Elaine asking if the same eviction rules would apply to commercial tenants.
Short answer is no. It's largely dictated by the lease, but commercial tenants, by and large, have less protections than residential tenants. Typically, it's only 30-day notice unless the lease says differently. And there's just a lot more access and lesser notice requirements for commercial tenants. I would highly suggest that you have a lawyer review your lease, because there's different form ones. Some people draft custom ones. And you know, we also do this kind of work. We do lease drafting for commercial clients, and we also do evictions. I've done several commercial evictions, and I actually enjoy them better. They're less personal. You're not evicting someone from their home. Although it's their business, it's typically a lot smoother just because there's less protections for the tenants.
Yeah, and Ashlee raises a good point. The big distinction, or one of the big distinctions with respect to commercial tenancies, is that the parties are given a lot more freedom to structure their relationship, including how the lease gets terminated and how an eviction, if it's necessary, proceeds. And so there's lots of tweaks that we could make to the lease agreement to provide advantage to either the commercial landlord or the commercial tenant, depending on who we're advocating for. That can be negotiation points that are part of that commercial relationship. So you can negotiate time periods, notice time periods, manners of providing notice. There's just a lot of more flexibility that is available to parties to a commercial lease.
So it's 11 a.m. Are you guys okay with staying on a little longer to answer some more questions?
Absolutely.
Great. Okay. So we have a question from Kwong. My tenant at first agreed with a rent increase, but now she changed her mind. How should I handle that?
Well, I'll start, pardon me, with two things. So every landlord-tenant question starts in two main sources of authority. Number one, the law and applicable local code provisions, and number two, the lease. So what I would need to know to appropriately analyze this question is to say, okay, well, what does the lease say about rent increases, and did the landlord comply with the lease in issuing the rent increase? And then also there's a couple state code provisions that come into play depending on the amount and the percentage of the rent increase. And so we would need to know, did you comply with state law in that regard? And then third and finally, if the property is located in a rent controlled jurisdiction, so here in the Bay Area where we are, that would be, for example, Oakland, East Palo Alto, San Francisco, Hayward, San Jose, as well as probably a few others. That's going to be critical, because noncompliance with that local statute, which can be difficult, right? There's a lot of very specific parameters placed on rent controlled jurisdictions and rent increases that may affect the validity of that rent increase. So stated somewhat differently, if the rent increase does not comply with state law or local law, It doesn't matter if the tenant agreed to it previously, it's still invalid. The tenant, by agreeing to it, cannot place him or herself outside of the tenant protection statutes. It's not a waiver of those protections. So that's important to know. And then secondarily, you know, this agreement isn't in writing. Most leases, at least most good leases, have provisions in there that require written modification in order to change the terms of the lease, a change in rent, certainly a change in terms of the lease, and that would need to be in writing and sometimes signed by the parties depending on what the lease says. So those are the two areas I would look at: local law, state law, and then the lease, to make sure that the rent increase complied with all those things. If it did, and it was compliant with all the requirements of the lease and the law, then the agreement's enforceable just like any other contract, and the tenant owes the rent. And so if the tenant doesn't pay, then the landlord is left with the choice to either A, renegotiate, which is always possible, and if it's a good tenant, you know, that could be a way to go, or B, to evict the tenant for non-payment of rent.
Okay, another question here in regards to, from Stephanie, says, we have a washer and dryer in our 2-bedroom apartments. One of our tenants is constantly calling us for repairs on the units. Should I wait 6 months after the last repair to issue the 60-day notice to vacate?
I'm sorry, could you state the last part of that question again? I didn't catch the last part of the sentence.
Yeah, I think this is in reference to what you were saying was that if you receive like a complaint from the tenant, should you wait 6 months after a repair to vacate them? So this would be in reference to the washer and dryer.
So I know Ashley's going to want to have some feedback on this. I'll just start with a kind of a more general point. With things like washer and dryer, those, at least in my opinion, are not habitability concerns. It's more of what was present in the unit and what does the lease say about that washer and dryer, right? For example, when I know that the landlord's going to be providing a washer, dryer, or any other type of appliance, I make sure that the lease specifies, when we're working with that landlord, that the lease specifies that the washer and dryer are either not part of the lease or somehow define that that washer dryer is not part of what the tenant is paying rent for, because it's not a habitability issue. It's more of an issue of, when I rented this place for $5,000 a month, you told me that a washer and dryer was included in that. So it's more of a breach of contract issue, or possibly on the part of the landlord. So with respect to that, because it's not a habitability issue, my opinion would be that that probably does not fall within the 6-month retaliation statute, but it certainly can if it was part of the lease agreement. So I'll just have Ashley then generally address the retaliation statute.
This goes back to Adam's comment of document. You can have a justified reason to evict the tenant and try to put that in writing. Say if you want your daughter to move in, or you want to move in, or you want to sell the property, have something evidencing that. And I would say go ahead and serve it in most instances, as long as you have documentation to prove that the eviction is for another reason. If you don't have any proof of any other reason other than a recent complaint, I would say, tread lightly. You're walking into the danger zone. But if you have evidence of other reasoning, I think in most cases you're okay.
Okay, and I do have a combination here that I kind of spaced because I had a feeling we'd get a few of these regarding the emotional support animals. There are about 4 people who put in questions. First one is, can you charge a pet deposit for an emotional support animal? Second is, what are some common violations of emotional support animal requests and how to avoid them? And is there any certifications or documents that you can require to show training of a service animal?
Yeah, I mean, the quick answer to all those questions is no. This is an area of the law that is obviously very tenant friendly. So kind of going through them, no, you cannot charge a pet deposit for any animal that is related to a tenant's disability. And disability includes traditional disabilities, like a tenant who is wheelchair bound and has a dog who helps with that, or a blind tenant who has a dog that helps with that. The law does not treat emotional support animals any differently nor does the law control what animal that can be. It can be a dog, it can be a cat, a bird, a snake. I mean, obviously there's some reasonable limitations to that that I won't get into. They're a little far afield, but it can be an animal of the tenant's choosing, and you have to treat that tenant as if the animal did not exist. You can't charge extra rent, you can't charge pet deposit, and so where most landlords run afoul of this is that they assume, and I think logically, that an emotional support animal might be treated differently or somehow not as important as a seeing eye dog. Now, while I as a person may have certain agreement with that, that's not what the law is. The law treats them the same. So they'll get an inquiry from a tenant and they'll have a knee-jerk reaction and they'll say, yeah, you can have your emotional support snake, but I'm going to need a pet deposit, right? So as soon as they've done that, they've run afoul of the law, and it's a bright line violation. So I have actually come across companies that fish for violations and then bring claims before the Fair Employment and Housing Office based on these email chains. And I think, again, it's largely innocent on the part of the landlord, but they react in a way that indicates that they're going to charge a deposit or somehow treat the tenant differently than any other tenant when they need to just simply ignore that pet's presence on the premises. So that said, how do you avoid that? One of my biggest pieces of advice to both property managers and landlords is slow down. You don't have to immediately respond to every email inquiry from every potential tenant out there asking about an animal. If it looks like that animal is in any way connected to any physical, mental, emotional, or other disability, hit the pause button and don't respond, we don't allow pets, we're going to charge a deposit. Just hold off, accept their application, treat it as any other, and then pick the tenant that's the most suitable for you. The bottom line is you're allowed to choose your tenants. You're just not allowed to choose your tenants based upon the existence or non-existence of any disability or otherwise. So take your time. It's the knee-jerk reactions that get people in trouble.
Good point. What about the service animal documentation? Is there a legitimate certification that can be required, like training of a service animal? Does the certification have to have the name of the patient, which is the tenant? And if they don't, can you deny them based on that? Where does certification come into play?
This is something that the law is very, it's very hard to comply with. So if I were to those people out there who have this question, if you intend to ask for documentation of the quote unquote legitimacy of a service animal, be incredibly careful and seek legal advice, because chances are, if you do it on your own, and this is not to disparage anybody's individual ability, it's just if you've not done this a lot, you're probably going to mess it up, because the basic answer to your question is no, you're not allowed to ask your tenant what their disability is or go into details about their medical information or even necessarily ask a doctor for certification. Now you can, I'm glossing over a lot of the law here. It just depends on, for example, if the tenant is blind and they show up with a seeing eye dog, you clearly under the law cannot ask for any verification of the legitimacy of that animal because the disability is open and obvious. Now where you go from there is a sliding scale, and emotional support animals certainly are on some other end of that scale as far as documentation. So you can seek documentation if you want. It's just you've got to be very careful about what you ask for and how you ask for it and when you ask for it.
Okay, so I think that's covered well, the emotional support part of it. Jumping back into evictions here from Kathleen, she says, we have an eviction settlement, and part of it was that the landlord can keep the security deposit and the tenant will vacate by October 31st. Since the tenant is still there, does the property manager give the owner the tenant deposit now or wait until the tenant vacates?
Well, that's a good question. Unless the settlement agreement says to give it earlier, I would go by the code. And the code says 21 days after they vacate. And so technically they haven't vacated yet. So it sounds like they would need to serve it by mail. Even though they're not returning a deposit, it sounds like you still need to return an itemized list with why you are not or what you deducted. It sounds like they would be sending that about the 20th of November, depending on when they vacate, if they vacate on time. I would still send it in your instance. I can't say definitively without seeing the settlement agreement, because that may dictate a different deadline, but it sounds like you can wait until 21 days after they vacate. But again, on the condition that I would like to see the agreement.
Great. I'm just writing this in for her. And I have another question.
I'll just add to that.
Yeah, go ahead.
Sorry, yeah, absolutely. We would need to see the settlement agreement to see how that was. And I'd also need to know a little bit more about the context of the settlement, because if the settlement was in the context of an unlawful detainer, there's a possibility that the landlord could have a judgment entered that would also then deal with the security deposit pursuant to the terms of the party settlement agreement. So it's very, very much agreement dependent, and there could be some additional options available to this person.
Great. Kathleen says, thank you. That helped. So I have a couple more questions. I'm going to just finish off with the couple that we have here. Please just put in your questions anyway if you still have some, so that I can email them to the speakers. The last question here, or maybe second to last, if we have a complex with 20 units, do we have to have a manager on site, or can we have an off-site manager?
Yeah, unfortunately, I'd have to defer that question. I'd have to double check the code on that. Off the top of my head, I know there is certainly a threshold. I just don't, sitting here at this moment, recall exactly what that threshold is. Certainly, if they wanted to follow up with us, we could definitely give them an answer to that question.
Okay, and then this other one as well, can I put in a lease agreement, for instance, that the tenant consents to receive communications from the landlord electronically, and that they may be communicated with by email, and that all agreements, notices, disclosures, and other communications provided electronically would satisfy a legal requirement that such communications be in writing?
The answer to that question is sort of long-winded, so I'll give you the short answer, which is yes and no. Not every type of notice under the law is subject to parties' agreement. So certainly there are certain things that can be parties can agree can be done electronically, and certain things that cannot be done electronically. So really, this is something that the landlord is going to want to address at the outset of drafting their lease and kind of going through. But I think, as phrased in the question, the type of broad electronic notice provision that the landlord is looking for, is probably not going to cut it. I would want something more specific that deals with the numerous different types of notice that are provided for by law, because there's due process concerns that come up in that regard.
Gotcha. Okay, well, we still have a few questions, but I'm going to just divert those to email. I think we've covered so much information and a variety of topics in the Q&A. I'm really glad that you guys stuck around. Thank you so much for answering those questions. And also, for the people still on the call, just a reminder, I will be sending the recording to you tomorrow morning, and also Ashlee and Adam's contact info will be in there, as well as the presentation copy and outline. And also, there is a post-webinar survey. Please take it. I do look at those responses on there for webinar topic suggestions. If you'd like to have Adam and Ashlee on again, please let me know. And I'd love to hear your thoughts on any future topics that might be specific to California that you would want to hear about, legal or otherwise. And with that being said, Ashlee and Adam, I really thank you so much for your time, and I hope to have you guys on again, and I'll be emailing you guys some follow-up questions from the audience.
It was our pleasure.
Yeah, thank you. Anytime.
All right, fantastic. Have a great day, everyone.